Thank you very much, Senor Gallegos, Mr. Moderator, fellow speakers, and distinguished ladies and gentlemen. It is an absolute delight for me to be in Peru, my very first visit to this beautiful country steeped in history and heritage. And I'm most grateful to Vice Admiral Tejada for inviting me to speak at this illustrious gathering, and also Captain Pedro Terry, with whom I have had a very long-standing association. I'm also delighted to see a cluster of WMU graduates sitting right in front, whom I've known over the years. And overall, this is a wonderful experience for me, and I just hope that I will have an opportunity to return to this beautiful country again at some point in time. As you will see here, I'm identified as Director of Postgraduate Maritime Law at Lund University, which is my present position. I know most people here refer to me as the Vice President of WMU, but that is a position from which I recently retired, although I'm still associated with WMU as a Professor of Maritime Law and Policy. Just to clarify that point, the topic that I was asked to speak on was a penal approach against piracy, common flaws in the national and international legislation and regulations. We would all like to think that there are no flaws, but in fact there are. I have shortened the title of my presentation to simply Penal Sanctions Against Piracy, but it will become apparent during my presentation that I will also be speaking on the offense known in the convention law as unlawful acts. I will also talk a little bit about armed robbery and hijacking and various other associated criminal offenses. But I'll start simply by giving you a very generic definition of piracy. And this is a simple definition which I think covers not only piracy in the sense of international law, but also in the sense of domestic law. And that is an act of depredation against a ship and people and property on board. Now, piracy, of course, we think about Long John Silver and about Johnny Depp and all these other characters that we are very familiar with in the modern literature and in the movies, etc. But piracy is about as old as seafaring itself, and seafaring itself is arguably the second oldest profession. I'm not going to tell you which is the oldest profession. Well, to get into something more serious, a pirate in international law is considered to be hostis humanus generis. In English, it would be translated into enemy of mankind. And piracy has thus been considered to be a crime in violation of what is known as jus cogens in international law. This Latin phrase means that it is a peremptory norm of international law from which no derogation is permitted, which is a very important feature of piracy as an international crime. Now, we heard about piracy under the Law of the Sea Convention from Mr. Metropolis, the Secretary General of IMO, yesterday, and you saw a slide which depicted the relevant article in the Law of the Sea Convention, that is Article 101. Let me just quote to you a very short passage from a recent statement made by the International Chamber of Shipping. And what it says there is that the problem of piracy, and we are really referring to the piracy off the coast of Somalia, that this is a problem that appears to be not so much an insufficiency of international law available to states to address the matter more meaningfully, but that they lack the political will to do so, particularly in terms of trying captured pirates and the reluctance to hold pirates in their states. I think it is a very significant statement that has been made, and I will come back to this point in a few minutes. But when we talk about piracy in international law, we're talking about piratical act being committed on the high seas. But we have to remember that not so long ago, the high seas only started about 3 nautical miles away from the coast. Today, of course, we know the high seas are quite far beyond. For certain instances, the high seas don't start till about 200 nautical miles from the coast. And for other purposes, the high seas or characteristics of the high seas are present in the waters just beyond 12 nautical miles. But if we just walk the clock back a few years, today we talk about Somalia, but then we talked more about the Malacca Straits. Now, most of the incidents in the Malacca Straits, if they took place before 1982, they would have been considered high seas piracy. But during the period that I am referring to, these activities which took place in the Malacca Straits were in waters that fell within the jurisdictions of the coastal states in that area. That would be Malaysia, Indonesia, and Singapore. Now, how could we deal with those incidents in terms of the law? And we coined a term known as coastal zone piracy, which has now become quite well known in the open literature, but we must take credit for generating that concept through a series of symposia on maritime security that we held at World Maritime University over a period of some 8 years. And these kinds of piracy-like acts, they fall within the coastal state's jurisdiction under international law of the sea, and that is why we would refer to them as coastal zone piracy. Now, what we see here, the main difference is that the location of the piratical act, whether it is on the high seas or whether it is within waters under the jurisdiction of the coastal state. But putting international law aside, if we look back at piracy over hundreds of years, we find that piracy is also a criminal offense under the domestic laws of states. What the provisions in UNCLOS do is that they have codified the customary international law of piracy. But there are interfaces and overlaps between the international law concept of piracy and the domestic law concept of piracy. And to elaborate on that, I'd like to take you back to some English case law going back to 1696, famous case known as the Regina versus Dawson. And in this case, a very eminent judge, what he said was that piracy is no different from sea robbery. It is committed within the jurisdiction of the Admiralty, which is a special kind of jurisdiction that English courts have. And in that case, in 1696, he said that if any is assaulted within that jurisdiction and his ship and goods violently taken away without legal authority, this is robbery and piracy. If the mariners of any ship shall violently dispossess the master and afterwards carry away the ship itself or any of the goods or tackle, apparel or furniture in any place where the Lord Admiral hath or pretends to have jurisdiction, this is also robbery and piracy. So we find that piracy is not simply an international law phenomenon, but it has existed in the domestic domains of certain jurisdictions for a very long time. Another very eminent judge, Dr. Lushington, said in 1873, he also talked about piracy being committed in any waterways, and this is a peculiarity of the English law, that the admiralty jurisdiction of the English courts extended to any place, even beyond the national waters of that state. He said that robbery committed in creeks, ports, and harbors in foreign countries constituted piracy, and that the English Admiralty Court indisputably had jurisdiction over piracy. Now, the reason I'm going on about this point is because the problem today, as I just said, according to the statement by the International Chamber of Shipping, is the problem is with enforcement. Now, of course, if we look at a number of incidents, recent incidents involving piracy, what we find is that there is a reluctance by states to exercise the jurisdiction that they have. Under international law, because